Good afternoon. If everybody morning, I guess we usually meet in the afternoon, but good morning, everyone. If we'll start to settle down, we'll get started here in a bit. So if we could just settle in. We got quiet today. We're going to call the meeting of the Higher Education Committee of the Georgia House of Representatives to order this morning. We have three items that with which we're going to deal. House Bill 319, House Bill 353, and House Bill 380. We have the author of 353 is going to go second in our agenda this afternoon. The first item I'd like to do, if I'd like to turn it over to the vice chair and ask him to call 319. And if we're ready to take action on that, I think we can dispense with that quickly. If it looks like there are detailed questions, Mr. Chairman, I'll hold that over. But with that, I'm going to turn it over to the vice chair of the committee to chair this section, Representative Scoggins.
Thank you, Mr. Chairman. This is House Bill 319 LC 500479. And Mr. Chairman, you are the author of the bill, so we'll hear from you.
Ladies and gentlemen, this is the bill we heard testimony on yesterday from the Georgia Student Finance Commission that repeals the code section dealing with the Georgia Higher Education Assistance Corporation that we heard hasn't been used in 10 years and will allow an administrative savings and even some dollars to return to the fund. And I just asked the committee's favorable consideration on that so we could move that item forward and quickly this morning. If there are no questions.
Okay, we have a move to pass and a second. All in favor of passing House Bill 319 LC 500479 say aye. Aye. All opposed, like sign. Off the rules.
Thank you, Mr. Chairman. And with that, we'll move directly. Well, let me go ahead and invite Chairman Powell up to the table if he is. And while you're coming, Mr. Chairman, let me kind of set the day for us. We do have a limited time this morning with a hard stop at 12 o'clock. We have two items that we're going to sound, House Bill 353, House Bill 380. We have sign-ups to testify. Quite honestly, with that limited time frame, we're not going to have room for a lot of testimony. I know there's a lot of interest in both measures, and be assured we're going to have a full and complete vetting of all of the measures. If we don't get to that full testimony this morning, we will early next week. I want everybody to feel at ease about having their opportunity, and we will carry over the sign-up sheet. If someone feels a need or has traveled and can't be back with us next week, probably as early as Tuesday afternoon, please let us know, let the committee staff know, and we'll try to entertain that. Otherwise, we're going to have the bill sounded, and particularly we have a substitute for House Bill 380. If you do not have a copy of that while we are in discussions on the first bill 353, let our office know, and we will work with you to get a copy of that. But we'll make sure before we leave here today that everybody has access to a copy of that for the weekend, and I'll address that further after Chairman Powell completes his presentation on House Bill 353. So with that, House Bill 353, LC 280563. Mr. Chairman.
Thank you, Mr. Chairman, and ladies and gentlemen of the committee. I'm not going to try to be long-winded, but I don't have any other choice because of this issue and the subject matter of this bill. Quite frankly, this bill has always been relegated to the regulated industries because we've worked over this thing for years. And it's so intricate, this industry as a whole, but I'm going to give you a little bit of a background. The COAM, which is coin-operated amusement machines, the history on these machines came, and it's been since probably before I was born or anybody here, and these things generated from the old carnival games when you won prizes. And as you all know, Georgia has a constitutional provision that we don't gamble in this state if it hadn't been approved by the voters of the state. That being said, these are non-cash redemption machines. And they have somewhat, the industry as a whole has somewhat of a checkered past. Through the inception of these games, they progressed into other types of devices. In the 90s, they got absolutely out of control with the video poker, for some of y'all that may remember that. There was a lot of major legislation in the late 90s and the early 2000s to rein this industry in, basically to get rid of the video poker, which was just outrageous that it was basically a lot of people in most locations were paying out cash. And a lot of that, for whatever the reason it may have been, it did happen. A lot of it was generated up in my part of the world on the borders of South Carolina. The legislation that came in basically was a start to cleaning up the industry. It banned certain types of machines, matchups and things like this. But these machines are for amusement. And the state has always acknowledged this for non-cash redemption. Now, as a footnote to that, I'd be remiss to say that for a state that so many people have a problem about gambling, people put billions of dollars into these machines to win non-cash prizes. Now, I'll give you a little bit more of the history. After the initial legislation of the early 2000s, the business crawled back up. Legislature passed legislations to put controls on it. The machines were put under the jurisdiction of a COAM division over at the Georgia Lottery Corporation, so that there was actual purview. Notwithstanding that, because law enforcement had control up to that point, but law enforcement oftentimes turned a blind eye to what was going on. And these machines progressively were, as they were put under the COAM division, things like tethering them to the lottery. So today the machines that you see, they're tethered to the Lottery Commission through whatever the electronic phone line, so the lottery can see what each machine does. These master licenses pay tremendous, license holders, they pay a tremendous license fee per machine and for the general license. The other flip side to that coin are the retailers. Now, I will tell you that a lot of the retailers, these machines are the difference between whether these stores stay open or close. Because the divide of the profits that go into those machines, the state gets 5% from the retailer and 5% from the master license holder. The master license holder, they furnish the machines. These machines go upward of $20,000 and $30,000 because they are bona fide amusement machines. You see all these new ones that are put out today with the fish and the kind of stuff like that. So it's not a cheap operation for these masters to furnish the machines under contract to the retailers. The retailers themselves give up valuable floor space for these, but they are a profitable enterprise both for the retailer and for the master. Each one of them pays 5% off the top, not off the bottom. So, you know, there's a tremendous amount of money. I will tell you at this point that the COAM machines in this state are the fastest growing revenue source per game for the Georgia Lottery Commission. Last year, I think they raised $140 million or somewhere in there, and it's varied several million cents. But that's because things have been legitimized as far as to be sure there's non-cash payouts. And I'll get into the rest of that in the bill. Let me tell you a little bit about the industry. This industry at certain times has been out of control, as I'd previously said. It's a highly competitive business. Anytime there's money involved, then the competition gets very aggressive and predatory. You have some 180 some odd master licenses that are currently in existence. And I would tell you that these are not just the big guys that you see that have fleets of lobbyists in the halls. Most of those are the small mom and pop operations. And I want to make a point to that because I'm going to give you an example of some of the issues that we're dealing with in this bill. The mom and pops has been in business for generations. They run the small routes. They have contracts with limited stores. But you have another fleet, probably 2 more tiers of these these master license holders. The bigger and the bigger, the bigger and the biggest. And you have 3 of the biggest, and you have a number 5 or 6 of the next size down, and then you get into the smaller ones, and that's how I categorize these machines. These machines come in two types, A and B. One of them does the what we call kiddie games, the crane games and the Donkey Kong or whatever I don't even know if they do Donkey Kong now, but I always liked that one when I was drinking in a younger life at the bars. But and then you have the other types, and that's the ones that are for non-cash redemption. They're supposedly skilled and such as that. They win coupons now. They can trade under the current law. They can trade whatever winnings they get on those machines that are of a point value for merchandise in the store. A lot of people will trade those for lottery tickets, or they'll buy gas, or whatever that store may have. We started talking about a gift card, and I'll get into the bill in a minute because I don't want to get ahead of myself. But there's a reason for that, and that's to try to dissuade any paying out of cash. I've told a lot of our members at times there's so much, in a lot of quarters, there's a lot of animosity toward the industry. They think everybody's crooked. They think everybody because of the nature of the game, but that's not true when I talk about the small operators and the big operators. We got folks that are doing it right. One, they don't want to lose their license. And 2, because of the legislators, those of us that are here today, we represent our constituents. And we want to feel the answers. So when I have, over the years, when I have had inquiries made to me about whether it's in Milledgeville or some small town about these crooked machines or paying out cash, all there are is casinos. Well, I have to ask at that point, where's the location? Where is that location? Because we can have it checked out. And when they say there's casinos, many casinos, and an abundance of machines, there's a limit on the number of machines. You can only have 8 machines. But a lot of those, what we've found is those are running absolutely illegal. They're not tethered to the they're not tethered to the lottery, and if that's so, then they're illegal. If they're not out in public view, if they're behind a closed door, like a speakeasy, they're illegal. So those are the things I want to bring attention to, because these folks that we're talking about, they're like every other business in this state, but except for the fact that they're contributing major tax dollars and major revenue that goes to the Lottery Commission, more so than anything else. So with that, I would be remiss if I didn't go ahead and get this elephant off the table. Regulated Industries we've had several oversight committee meetings of the lottery. We're remanded by legislation as oversight. There's problems over at the enforcement division, and I'm not going to make accusations or get into it, but some of y'all may wish, as I'm fortunate that I see this committee, that I see a number of the members of this committee that also serve under Reg Industries, and they're familiar. They were there at that meeting. But I would say to the committee members that were not in attendance, you need to go to the House website and go to the Lottery Oversight Commission. It was held about 3 weeks or so ago, and you need to listen to it, because that's very bearing on some of the issues here. And I'll move on from that. But the bill itself, this is an annual cleanup bill. Well, it's not even annual, because I've been trying to get this bill passed for 3 years. And because of the lobbying efforts in the hall, we have companies out there, and they want what they want. Everybody's got a different business model, but there's a common thread to all of them, and that's about trying to do the right thing. One of the things I promoted for years was a gift card. The lottery did come up with a gift card as an experiment, and here it is 2 years later, they're still experimenting. because they haven't gotten it universally around the state. But at testimony at that meeting I referred to, they actually admitted that, well, this is working out very nicely and is producing more sales. The retailers that are participating in that supposed pilot program, they like this idea, and they're getting more and more folks who want it. So I make that mention because when I get into the section of the bill that deals with that, then I'll get into maybe further explaining. If you'll look at the bill itself, there's several parts of it. I'll go over the main parts. One allows for gift cards for redemption. These gift cards will be any gift card, whether it's you name whatever the gift card, that for any points wins, they'd be paid with a gift card. What we've promoted and what I've been promoting for years is an open loop gift card. They'll buy the gift card, whether it's from the lottery or from whoever puts the gift card out. And then that gift card, once they put whatever cash they want to put into it, they put it in the machine. If they win, it downloads it onto the gift card. And they can use that gift card for any legal product in the state of Georgia. And I'm telling you that because one of the things that I suspect, and I am a true believer of this, that once you get away from having the limited number or the limited amount of in-store purchases, you will see the proceeds explode in the state of Georgia. It will explode, and it'll bring in more money to the lottery. A lot of predictions saying it would double the amount of money that would go to the Georgia lottery. Increases the value of the prize on the Class A games. These are the ones I was talking about, the kid games. Right now, we've been stuck for, I guess, since the beginning of mankind, or this industry, that these crane games and those kind of games, I call them sucker games, quite frankly, because even under the influence, I've never thought about putting money into a game to try to pick up a shiny gold watch or something. But it's always been at $5, which is basically past that day. Most states go up anywhere from $50 plus to $100 for the prizes. Now, if that sounds like it's a sucker game, well, you can put your own view to that. But we're raising that limit to a $50 cap on the prizes that are put in these type of games. Third point. One of the problems that we have seen is that in the COAM division at the lottery, they're not under the Administrative Procedures Act. And I can talk longer than y'all want to be here today, ladies and gentlemen, but because of that, they do what they want to do. There has been some internal strife over there about rules and regulations and things like that. But anywhere that you do not have sunshine, and I say sunshine to purview or to review the rules and regulations and the operations, there's always going to be problems. So I am proposing that we put the COAM division under the Administrative Procedures Act for the purpose of seeing what they're doing, how they're enforcing these laws, and to basically have comment from the legislative oversight before the rules and regs and some of their actions are enacted. There's another section, there's a fourth section that exempts veteran and fraternal organizations. When I spoke about back years ago of the major problems 20 plus years ago, one of the things we did was say that if you're going to have COAM machines, you got to have what we call a 50-50 rule, that 50% of the merchandise or whatever has got to be non-COAM related. Well, that doesn't apply when you've got your VFWs and your AMVETs and a lot of the fraternal organizations. They don't sell merchandise and such like that. So what we're doing, we're opening an exemption for them that's tightly regulated so that they can get back in to having these machines at their facilities for these. And this is strictly for veteran and fraternal organizations. And they are in very high support of this, ladies and gentlemen. Something that might seem to be very trivial in this important legislation. The COAM division has made a ruling that electronic darts and pool, and remember, coin-operated pool tables fall under the laws of this also. But the COAM division has ruled, oh no, y'all can't have tournaments. We live in a real world that people do enjoy these things. You go to a bar, you go to whatever, and they have dart tournaments, electronic, and they don't throw because of, I'm sure because of OSHA, they don't have real darts anymore, but it's these, electronic dart machines and pool. And that would allow them to have tournaments. Quite frankly, as a recreational, and if these machines are supposed to be for recreational enjoyment, then let's make it for what it is. So this would allow for dart games and billiards. Another section of this bill, it deals with property rights. Now this is a complicated part to get into. Sometimes it even boggles my mind, and I've never been satisfied with a lot of it. But because of the predatory nature of this business, a lot of the masters are always looking for ways of getting new clients. They have to sign a contract. It's on record with the lottery. The retailer also has to be background and has certain requirements they deal with. But because of this, you have a lot of the masters, or some of them, I ain't gonna say a lot, but some of them, they go to somewhat extreme measures to take these clients back. Well, we have found over the years that all that does is it invokes a lot of wrongdoing. And because of that, there's certain legal requirements on the contracts, such as a 9-month extension on a contract if they don't dot the I's and cross the T's. And this is for the protection of the contracts between the masters and the retailers. A lot of legalese, and there's people here that are better prepared to address that for you than I am, even though I've got my own views about it. But at the end of the day, one of the things that me and others have been concerned about is the legitimate property owner, the landlord. And remember, and I'll say this, that in this, if you're a master, you cannot own the property that you furnish machines to. And the reason for that is that if the master who's furnishing the machines owned the property themselves or had an interest in the retail, then they could do about anything. So we hemmed this up years ago. But because of that, it's made it such a lucrative business. There's a lot of clever maneuvering that goes around to steal clients, like inducements that are illegal. Some of these things are just strictly under law. You would think that a lot of this is just outrageous that we have to do that, because I come from a world where if I shake your hand or much less sign a contract, I won't live to what I said. But when you have inducements to get a retailer to move from one master to another, that's what has created a lot of the issues and the conflicts and interest in this industry. When I talk about balancing the rights of these property owners, I'm a landlord. I was in the C-store business for my earlier life that helped to educate my children, and I raised my family out of it. I went into the real estate business years ago because, quite frankly, standing on those concrete floors as a retailer is the reason I've had knees replaced and a lot of other illnesses. Now that I'm of a senior nature, not that y'all may think I am, but I really am a senior. Yeah. My hair's not as gray as yours, my friend, but trust me, when I get up every morning, I can tell you what the weather's going to be. But we have put language in there to protect because of the contractual protections. Then we put some language in here to protect the landlord. If a tenant to my property goes out of business, legitimately goes out, not to put a straw tenant in there, then we've given the landlord and the property owner the rights to file an eviction notice, and once on file, then that property owner can release his property to whoever he wishes. That's the free enterprise system. But it's regretful that in our society today that a contract doesn't mean anything. But that's the nature of a lot of things these days that we're living in today. Some of the rules and regs that we have no control over, to me, don't make a lot of common sense. when we say no inducements that a master may give to a retailer, the lottery has even gone further to say, well, you can't put a sign on the wall to tell people how to play the game. This is outrageous. Because with a COAM machine or a video machine, there needs to be a stool or a chair or whatever. There needs to be certain trappings that follow that. One of those trappings would be put a sign on the wall. These are for non-cash redemptions. This is the rules. This is how you play these games. So we're saying that there's a limited amount that can follow that could be provided with the machines to the contractual lessee at the stores where they are. And then last but not least, there's a section in here about frivolous arbitrations. We have some masters that I have heard that have filed litigation against a retailer because they didn't dot an I across the T before they let their contracts expire. Because they know that as long as they're doing it, they're going to keep that. They're going to keep that contract for a little bit longer. And what we're saying in here, ladies and gentlemen, is that if they do that and it's frivolous, then let the loser pay. Disgorgement of the legal fees and whatever's lost. That's what the bill does. It sounds kind of simple the way I explained it, but there ain't nothing simple about this. We've tried to do these changes for several years because of the nature of the industry and some of the lobbying efforts. And there's some other things I would have to tell you. I mean, the unfairness that I'm speaking of a lot of the issues that are done. The predatory nature of this and some of the concerns that I have about oversight from the governing authority, which is the COAM division. We've had a lot of things that's happened, such as somebody gets a master may be caught doing something illegal in what I call the deadly sins, such as owning property and putting their own machines in there, enhancements or incentives to get people to change over. Well, that's the deadly sins. You lose your license at that. Well, strange enough, there's been 20 some odd masters that's lost their licenses and they were incurred large fines. But in the encouragement of losing their license, instead of their licenses and assets being auctioned off and let the fair market prevail to pay the fines, they have been steered to transfer those assets to be approved by the COAM division. One of the things that I'm pushing, and there'll be a separate bill that's going to be introduced that mandates that if there is a deadly sin and somebody loses their license, that proceeds will have to be auctioned off. Now let me give you another story to this. And if I sound like I have animosity toward the governing authority, I do, because I think government's better than this. One of the big three was a certain company, and they got caught dead bang last year of owning properties where they had their machines. Deadly sin. Through the proper due process of hearings, then they would then lose their license. Then they got caught with a second offense of doing incentives and enhancements. The COAM division chose to do a non-license renewal. I don't know what the difference in that or a revocation of the license was. They were fined $10 million. Now, I don't know what the total assets. I'm told that the total assets must have been pretty extreme, because I've heard that the hedge fund companies were on the hook for about $140 million in loans to this company. Whether that's true or not, I can't verify it, but I just know what I'm told. And the COAM division did a non-renewal, and then they filed. The company hired a lawyer, one of our own, very sharp attorney, and sent out a letter threatening legal action. The lottery division decided to use their own judge, which there's hearing officers, something that I certainly do consider inappropriate. The COAM and the lottery division, they have their own enforcement, but they also pay their own hearing officers. They pick their hearing officers. Now, they tell me they're up to 3 now, even though one is the only one that seems to hear the majority of the cases. He's been on the books for years. So the lottery, if there is in the due process provision that everybody's guaranteed, then the appeal or the case would then go in front of the hearing judge that the COAM division hires. They have their own courtroom over at the Lottery Commission, which is inappropriate to me. It needs to be an independent hearing officer, quite honestly. The hearing officer ruled that the lottery couldn't enforce this, that they had to let them off the hook. They skated off of a $10 million fine because they're going to be able to get rid of their assets. So there'll be no fine. At the same time, and I use this as an example, that last year there was a mom and pop operation that I knew down in South Georgia, small operation, small master license COAM. And the guy, and I'm not going to mention the names, but the guy, the original father, had put the COAM license basically in one of his son's names that had worked in the industry. The guy was getting older, so he put it in his son's name. He had this license in his name. Supposedly the son was good at running routes and machines and all of that, but the father had concern because another son who was in another business was much more of a astute businessman, as best I can say, and I don't mean that derogatorily about this. And in the common way of doing business, and I look out and I see a lot of y'all that are business people, and y'all understand that what we do in business, we use LLCs, and we use them for a purpose. And this family, he set up an LLC for the second son to advise the son that was a master holder. Nothing illegal. There were no joint bank accounts. The LLC didn't have anything to do with running the company except to advise. And they levied a $100,000 fine on this company. And it took interceding with the executive branch. And the answer came back was, well, we're going to lower this fine to $30,000 because we're going to do them a favor because we can't just do away with it because we don't do that. We can't risk letting them off the hook, even though under advice, never should have been a fine or never should have been a case even made. My recommendation to the guy, even at the $30,000, was you need to get your lawyer to file an appeal on this and take it forward. And his response was, we're going to pay the $30,000 because we're afraid of them folks. We're afraid of them. Ladies and gentlemen, I would tell you, and I'll continue to say it, we're better than that. That's not what government's supposed to be about. But I would tell you that anytime you have an industry that has this type of money and finances and all that involved, it creates a lot of corruption, intended or unintended, whichever it may be. That, ladies and gentlemen, is this bill. I would tell you that this is still a work in progress. We've had numerous meetings with the COAM members. There is a professional organization called GMOA that represents mostly a lot of the big ones and the small ones. A lot of the big ones aren't a member because they got enough money to hire their own lobbyist and the such. It is a work in progress, trying to get all of the parties to the table. The nature of the industry is changing because, quite frankly, a lot of the lenders are making them change. So that, ladies and gentlemen, is what this bill entails. Be glad to stand for any questions. I'm sorry to be so long-winded by giving you the history of this, but I want to thank you for your time.
Yes, sir. Thank you, Chairman Powell. I'm going to go to questions, and I love our committee, and I appreciate all the members. We get we get good questions, but sometimes we get confrontational, not confrontational, conversational as we do our question. Given the time and the matters, we'll have ample opportunity to discuss the merits and specifics of the bill and You know, should it come up for a vote, we'll have a robust debate on it. But I'm going to be a little more pointed than normal on let's ask questions of the gentleman, and we can save our comments and debate on the merits of the legislation to a later date. So with that, we're going to go to questions. Dr. Clark.
Thank you, Mr. Chair. So, and thank you for presenting the bill. My question really comes down to semantics. A gift card that is redeemable off premises, would that not just be considered as good as cash and therefore cash? And then would that not make this entire thing unconstitutional in the state of Georgia?
No, ma'am. The interpretation by the courts and case law and others is that gambling is the paying out of cash, not gift card or not gifts. And this goes back to the day of the old carnival games and all such as that.
Thank you. Number 28, Chairman Perkle. There you are.
Yes, sir. Thank you, Mr. Chairman. I'm clearly out of my league on this one. I know a little bit about some things and almost nothing about this. I think you mentioned in your testimony that there are approximately 183 licenses. And I noticed in Section 4, the 220 Class B master license is still in fact. So we actually have more authorized than what we have, so we're not picking winners and losers in this. Is that correct?
Well, if you're saying the number of licenses and how this matches, when I talk about the predatory nature, a lot of these COAM masters have bought others. They're buying the smaller ones out. So you may have some that may own 5, 6, 8 different master licenses.
So it is your contention that is fully subscribed, perhaps that is a better way to put it. The master license would be fully subscribed?
Explain subscribed.
I think if I can help here, I think what the gentleman said, if somebody in the room wanted to,
If I wanted to get one.
a master license, is there another one available in Georgia? As
The
we
Lottery
said today?
Commission can now auction off a license. I think it's once every 3 years, maybe. I have to search my memory. There's so much dust in my mind from all of this. But they can auction off one every so many years, like every 3 years maybe. But most of these are done by buying. Companies, people who want to get into this business, they'll make an offer to try to buy them. And usually it's the smaller operations. It's usually the older licensees that they're basically tired of dealing with it, and they'll sell their company.
Part B,
With
would that be
permission.
okay, or you need to go on? So according to testimony, the gift card part of this legislation would be a win for the industry. A way to clean up, to make, to work out the bad actors, and it would be helpful, perhaps a doubling of revenues. The question I have is, if it is so lucrative, is there any measure where perhaps the state share could be increased?
My recommendation, and I'm very familiar with that argument, at this point, I have said that I'm not opposed to looking at that, but I would recommend that we do the gift card. And remember, these gift cards, to Ms. Clark's question, these gift cards, when they're issued, they can be construed, whatever the technology, so that there's no cash payouts. It's got to be for merchandise. So that takes care of the other problem of any further cash payouts. Because quite frankly, anybody that pays out cash when a gift card's available, they need to be kneecapped because they're too stupid to breathe. That legitimizes the fact of no cash payouts. If this does what we think, my recommendations would be put the gift card into full effect. When we see, after 12 months or whatever, the dollar amount, then that's when we could go back in and then try to adjust. Right now it's 5% from the retailer, 5% from the master. Now, I'm a businessman, been a businessman all my life. I understand that message. I know what I'm paying right now in the highest taxed industry in the state. But if you put a gift card out there and I'm making another $100,000, I wouldn't mind paying a little bit more. But the idea of let's just carte blanche before we see what's really gonna happen to start raising the taxes, my recommendation would be at that point, once we have a historic perspective on what a gift card's gonna do, then look at whatever the will of the General Assembly. Because quite honestly, I've never seen a revenue source that legislators ain't willing to tap into, no matter what their political affiliation might be.
Thank you, Chairman Powell. Then thank you, Chairman Perkle. I want to point out, just for a moment of levity here, that the gentleman, the graduate of Georgia Tech, said approximately 383. Right? Not approximately 180, but 300. You had the number exactly right, Mr. Chairman. You're right on it there. Representative Holland.
Thank you, Mr. Chairman. Chairman Powell, first, thank you for introducing me to the concept of a sucker game, because the next time my child asks for $1 for the claw machine, I'm going to let him know what a wise man calls those games. So currently, as I understand it, when you win points from the COAM and you can exchange them for anything within the retail store, does that include being able to exchange them for cigarettes or alcohol? And is there any, if there's no restriction on those, I'm assuming there'd be no restriction on how the gift cards could be used as well?
Currently, there are restrictions, alcohol, I believe tobacco, firearms.
Got it. Thank you. And
Yes.
and would those restrictions carry over to how a gift card could be used, or would that be?
This gift card we're proposing is any legal product.
All right. Thank you.
Thank you, Mr. Chairman. Just want to get into a couple technical things here, Mr. Chairman, and ask you a question or two, starting at Section 6, and maybe just speak to us about the importance of changing from the 9 to 24 months and why that may be important to the industry.
Well, right now it's 9 months to carry over on the contracts if the retailer didn't dot I's and cross T's in a period of time. This moves it to 24 months. Supposedly it would give more guarantees for the contract, that the contracts are basically enforced.
Thank you. Can I have a follow-up or two, Mr. Chairman? Skipping back to Section 4, I think previously it says that they're supposed to issue one at least once. Are they doing that now? Are they auctioning off the licenses the way they're supposed to at the lottery?
You know, I couldn't tell you because we don't, we have the oversight, and you know, that might be one of the questions that wasn't asked. I mean, the Regulated Industry Committee fielded 4 pages from the members of questions to the lottery.
Because we're changing from at least once every 3 years to just once every 3 years. So they could be doing 10 a year,
Sure.
or 10 every 3 years, but now we're making sure they're only doing 1 every 3 years. So we're
Right.
kind of cutting that some, right? And one more follow-up, Mr. Chairman, if I can. Looking just at the effective date in Section 9, saying that the act will become effective upon the approval by the governor or upon it becoming law without such approval. Just thinking through the work that the lottery may have to do to implement some of this, don't you think it would be reasonable to give them a little time to get rules and regulations in place outside of just upon the governor's signature?
Well, I would tell you, I don't think that would be correct because that's a management decision that's got to be made over there. They have a general counsel that has not had purview of the legal department of the COAM, is what we were told. All they got to do is do the way they need to do. The rules and regs need to be publicized. As I understand, a lot of the rules and regs over there are up to the interpretation of the COAM division, nobody else. And as an attorney, you know the importance of that needs to change. That if they've got rules and regs, they need to be publicized, and it needs to be a standard of how they're being interpreted.
I agree with you. I have a concern about not giving them a little time to get up to speed with. But we can deal with that in the discussion, Mr.
Yes,
Chair.
sir.
Thank you.
I appreciate the question.
If I may add to that, I will give the president of the Lottery Commission credit that I think that she heard the message loud and clear. She's preparing answers for all of these questions, including when and where and what changes they're going to make and how soon they're going to be making them.
I can echo that, Mr. Chairman. That office has reached out to us, and they're willing to work with the author of the bill. She specifically mentioned that, and members of this committee and those on regulated industries to continue to improve the processes around this. Representative Holcomb, Scott Holcomb.
Thank you, Mr. Chairman. I want to follow up on Representative Kelly's question because I don't understand the answer of what do you mean by not crossing the T's and dotting the I's and how that impacts 9 months to 24 months? That makes no sense to me. Can you explain that?
You know, it's such a nature that, as you know, being an attorney yourself, that a lot of the masters that are of a certain nature, they have their own legal staffs. And not that I would think that any lawyer would do anything scurrilously to stop a contract, but they do certain things. Now, there's someone, we have a member of the Representative Gamoa who can probably answer your question because he's an attorney as to give you a definition as to why and what's necessary. If y'all want to call him up, I'm sure he'll be more than glad to answer that question.
Okay. Yeah, I'd like more clarity, and we could have it offline, but I would expect that both parties would have lawyers to review this. And
I'm sure that there's no need for offline. I'm sure he could just, if I could hone him in, just answer that without getting on anything else. He could answer that question. If it's the wish of the chair.
Is he with us today?
Mr. Snyder.
Oh, just stand up over there. You're not going to be here that long. No, I mean, you need to get in front of, I'm partially kidding, but you do need to get in front of a microphone.
No.
Mr. Snyder.
No, and I'll also tell you, that's a wise comment that you made.
I don't want you to get too comfortable. You know I mean, in all seriousness, you know so much about this subject that just to identify yourself for the record.
Les Schneider, counsel for the Georgia Amusement and Music Operators Association. Scott, I want to make sure I hone in on your question. Your issue is why go from 9 months to 24 months, or you're talking about the elongation of the contract? I just want to make sure I've got the question right.
I'm trying to understand why it's moving from 9 months to 24 months. What we were told was because of contracts, they're not dotting the I's and crossing the T's, and I don't know what that means.
The issue on that rule is the fact that there has been some problems where a location licensee who signs the contract with the master will sign the contract, and when the contract that he signs is for a longer term than his lease actually is with the landlord. So Representative Powell talked about making sure we balance the property rights of the landlord with the rights of the contract. The purpose to go from 9 to 24 months is twofold. Number one, it's to discourage anybody giving somebody else an inducement to try to change the master at the location. But the second issue is, as you see in the legislation, that the landlord who uses an eviction to evict the tenant who is either not paying rent and no longer at the property, that would vitiate not only any 9-month rule, but a 24-month rule. So he would be able to have his property and could lease it to anyone he wants, and that person could go with any master that he wants. On the other hand, we want to discourage any inducement that either a master would make to a tenant, who is the licensee, or to the landlord to try to throw somebody out. And at a 24-month period, that would be too expensive an inducement to make. At a 9-month period, it probably might not fix the situation. And again, as Representative Powell indicated, this is an area that we're still trying to compromise and come up with the best solution. But it's largely to preclude inducements. It's also, to Representative Powell's view, that we don't want masters or location owners engaging in frivolous litigation. And as you see toward the end of the bill, if the arbitrator decides it's a frivolous litigation, he will disgorge the losing party of any monies that they have earned during the period of the litigation. So when we are trying to eliminate that bad behavior.
What are examples of frivolous litigation if this is a rampant problem?
It would be the same level that would be in a court. The best example I could give you is if I am a tenant, I'm the location licensee, I have given you proper notice, the master, that I want out of my agreement. I don't want to have you as my master anymore. You, as the master, file a dispute, even though the notice has been timely given, and you're just gonna stretch it out another 6 months, another year and a half through the court system. And there have been some masters that have done that, and we want to discourage that behavior. That's on the master side. Tenants will also have questionable conduct because they don't give notice, yet they file.
Yeah, this is where I didn't want to go. I don't want to wax on you. I mean, the gentleman's question, what generates the dots and I's, because is contractual ambiguities between the people, and I am going to ask you to get with the author and them to do it, so we do have another measure we have to do, and again, I appreciate it, and it's for your vast knowledge, not lack thereof, that I want to move us along. Is that okay, Representative Holcomb?
It is, and I also don't understand Section 7 with like limitations on posters, signage, and all that. But we can have an offline.
Yes,
discussion
sir.
on
This is
that
our
too.
first. Thank you. Well, we'll do it in the. You're welcome to speak with him in the public, but in private, but we'll do it all publicly for sure. Number 22, Chairman Knight.
Thank you, Mr. Chairman. Chairman Powell, I know you're passionate about this bill and certainly the issue behind it, but I do have a legitimate question. And that's in regards to the gift card. And, again, as you've alluded, there's been issues within the industry. The Supreme Court case basically says, hey, it's not gambling if it's a gift, right? But in all reality, if you issue me a gift card, it can be monetized. And so, I want to go back. That's an honest question. Because if I'm in there playing, not that I do it, but if someone is in there playing games and they're getting gift cards, then they can go out and monetize that, sell that to somebody who could take it anywhere and use it for any purpose, thereby, allowing more cash back into the pocket of the person who's doing the gambling. So that's my first overall question, but I'm also trying to understand if you're monetizing this, a gift card doesn't give you, it may reflect a transaction or a win, okay, but it doesn't, per person. What if I'm in there 12 hours a day and I've got $1,000 in gift cards? What, I'm monetizing it, and that's a legitimate question. And let me say why this is legitimate. More than a couple years ago, law enforcement in my district had come to me, and there was an older gentleman who was at these local C-stores, and there were some bad things happening. He ended up running through probably close to $200,000 of his life savings in retirement. True story. So there are issues there, and I'm not sure how this gift card would prevent that. And if you could speak, because that's a true story to my friend.
Well, first, I take any question from my friend to be very serious.
Very serious.
And I will tell you that this goes back to human nature. The gift card itself is what I have been told, and even the gift cards that the lottery is using in their pilot program, that allows folks to put it on there, but that eliminates the paying out of cash. Now, would somebody take their gift card that might have $100 or $200 or $1,000 on it? Would they take that and sell it to somebody else? Been no evidence of that. Don't know why they would. Because those folks that sit in front of a game machine, quite honestly, I answer your question, somebody that may sit in front of that game machine, then they have an addiction, quite honestly. Now, we can't control people's personal behavior. That's the reason that Delta flies every day to Las Vegas and Biloxi and places like that. To me, it's hard for me to fathom somebody who sits in front of these machines and does this, because they obviously don't have a life, quite honestly. But I don't know how else that could be controlled. I know that the gift cards, as explained to me, have so many controls on them today that they could be basically geofenced. They can be programmed not to allow any cash to be redeemed for them. So whoever's got them, no matter what, they're going to have to go to a location, whether it's go to Ace Hardware or go to Home Depot or go to Longhorns or wherever it is, to trade that for whatever merchandise it is. And it's just the nature, quite frankly.
Dr. Clark, I see your point. We've gotten to 1 hour. I'm going to divide it equally and ask us if you can hold that question when we have the bill before us next time. Given that we were trying to split the time, I'm going to ask, we have some signers that wish to speak to this. We'll hear it again. In order to get to the presentation on 380, is there anyone signed up to speak on 353 that can't join us back again on Tuesday? Again, we're trying to do that. Yes, sir. If there's anybody that legitimately can't join us back on Tuesday, I'll give you a couple of minutes to speak to this. If you come to the microphone. And I appreciate the indulgence. The idea, as I said earlier, was to sound both of these so that folks would have them over the weekend and we would have them back. So with that, you're gonna have to introduce yourself because there's several people that have signed up. Tell us who you are, and we'll also keep the list and the priority on that. Yes, sir.
Good morning, Chairman and committee members. My name is Jamie Boyden. I'm an EVP for Business Development with Lucky Bucks, a climb operator in Georgia. We've reviewed the sponsors bill and see it as a great start. We've been and will continue to be engaged with the sponsor and industry participants in discussions to improve this bill. Our issues, by and large, are not with what is in the bill, but really what is needed and not in the bill. We've crafted comprehensive language that we believe provides needed guardrails for the industry and addresses both structural and regulatory concerns that have become pressing since the last session. These changes are needed given that the sponsors bill is intended to rapidly expand co-am gaming in Georgia. And we have widely circulated this proposed language to legislators and industry stakeholders and look forward to their engagement with us going forward. That's all we'd like to say.
Thank you very much.
Thank you.
Thank you very much. I don't see anybody else that has that can't join us next week, and we will. I promise you, we will have that out there. Again, our goal today was to get this out and heard, and to start the process. So with that, you don't have a lot to rebut, but I'll give you.
No, but I would like to thank the chairman and the committee for taking time to hear this, whether this bill stays here or not. According to Mr. Jamie, what he had just said was that this is a working motion right now. We continue to have negotiations because of the nature of the businesses and the size of them. Quite frankly, the problem in the past years have been everybody wants something else to work for their business model instead of working for what's in the common good to clean this up and make this a more viable industry with the guardrails, as he spoke of, that would make it a better industry and hopefully to change some of the actions. So that being said, I do want to thank each and every member of this committee. And whether I see you again on this issue or not, hopefully we'll see each other somewhere.
Yes, sir. You'll see me one way or the other, either in front of this committee or sitting on yours, Mr. Chairman. Thank you very much. We'll move on directly to House Bill 330. I'm sorry, 380. The LC we're dealing with, members, is LC 30. Well, I'm going to make sure of this. LC 365493S. Is that correct, Chairman Wiedauer?
Yes, 5493S.
5493S. Now, let me say this. We have this in a PDF format in our office. We're working on getting that available. So to be clear to everyone here, until a committee takes action, once a bill is introduced, until a committee moves it to another place, it doesn't get updated on the House website as the current version. But the version that is current, with which we are working, right, Chairman Wiedauer, is LC 365493S, and that's the bill the gentleman's going to present to us today, and we're going to make an effort to get a connection to that on the House websites somewhere out there in webland, so that we would get that bill to anyone that needs it. So with that, Chairman Wiedauer.
Thank you, Mr. Chairman. Just want to start with, obviously, over the last couple of years, there's been a lot of conversations revolving around sports betting. I am bringing the lottery game of sports betting. My interest in doing so is, I've used this example. I feel like I'm the parent that's come home from work. The kids have been arguing all day long, and I'm simply trying to put them each in their corners and making sure everybody's doing the right thing and everybody's got the proper guardrails to protect Georgia and put money where it should be going. So with that in mind, I'll get into this. I know that this is, the standing joke is a simple bill. Just happens to be 45 pages long. But I am going to go through section by section, and I will try to do so quickly, and then hopefully leaving us enough time to answer some pertinent questions. The biggest difference between what we originally dropped and this substitute is that this substitute is online only. There is no retail function of this. There is no COAM. This is strictly online lottery game of sports betting, period. All right, we'll get into the bill. So if we go to part 1, page 3, line 27, section 1.1, this is just that it is going to be a lottery game. Simply is that. It clarifies that pari-mutuel betting is not sports betting. I wanted to make sure that it has this bill has absolutely nothing to do with horse racing, nor does it have anything to do with casinos. That is covered in section 1.1. Section 1.3, page 359. This is reserve language. There's obviously been some conversations about how much money is in the lottery. What this simply states is that the 50% reserve will be maintained, but if they have more money than that, they need to allocate it appropriately. We are not getting into anywhere in this bill how the lottery spends their money. It is already dictated in a constitutional amendment that created the lottery, so we're not getting into further if there's interest in that. As I've suggested, so many other people that are interested in this bill, they can do that on a different bill. You'll hear me say that kind of throughout this process. I'm not really in this to make friends. I feel like I've said no more than Richard Smith has. So part 2, section 2.1, page 5, I believe it's line 82. I can't even read my own handwriting. Names the bill, the Georgia Lottery Games of Sports Betting Act. Gets into the definitions. This is where you'll see adjusted gross income, what a master sports betting license is, sporting events, type 1 eligibility entities, and then tier 1, tier 2 sports wagers. I'll real quickly go through some of that. The adjusted gross income, that's obviously how the state is going to collect money from licensees. Very simply put, it is basically all the money they've made. We're allowing them to take off the top the federal taxes that they pay, as well as the wagers that they're paying out. They'll take that off the AGI. Currently in there is some language that allows them to take from the AGI some incentive money. They'll say, hey, if you come bet with our organization or our operation, that we'll give you $100 to start out. I will tell you that I have some heartburn over that. And you will probably see some language in a future substitute that will probably be omitting that from the AGI. But I do want to note that it is there and kind of give you my mindset on moving forward there. The master sports betting license. This is for the lottery themselves. If they would like to run their own sports book as the Georgia Lottery, this merely allows them to do so. And we'll get into later in the bill all the number of licenses and where those go. Sporting events, obviously, so you'll see a Type 1 eligibility entity. The reason there's a Type 1 and you don't see any other types is because Type 2 used to be the retail portion. So for purposes, obviously, of getting this substitute out, Type 1 has been left in there, but I just want to note there is no other types. That merely is the online licensees. Tier 1 sports wagers and Tier 2 sports wagers, that's just the simple difference between an outcome-based bet like an over-under versus in-game betting, whether or not Tiger Woods is going to miss a putt today. Moving on to page 12, line 281, section 5027-123. This basically is how we are going to regulate this effectively. It gets into the language of their ability to license the applicants and what jurisdiction they have over those applicants. The ability, and it gets into the language of how their ability to subpoena witnesses for investigations for corporations and what have you. Section 5027-124, page 15, line 356. This sets the rules and regulations the lottery must set around just everything that a licensee would have to operate. So insurance requirements, audits of licenses, financial reports, etc. Part 2, which is on page 16, line 377. This gets into all those requirements a little bit more in depth and what we require of them. This is where you'll see on line 454 and 470 through 470 the amounts for these licenses. You have licenses for sports betting licenses. You also have licenses for online sports betting service providers. Let me explain that for a minute. So let's say the Atlanta Braves get a license to run an operation. They actually don't have a sports book, right? So they're going to probably partner with some entity that has that kind of operation. So the licensee would be the Braves. The license for online sports betting services would be the entity they partner with. So there'd be two different licensees, two different levels of licensure. So in that example, the Braves' annual license fee would be $1 million annually. They would have an application fee of $100,000 that's non-refundable. The licensee that would run their sports book would have an additional application, and there would be a non-refundable fee of $10,000 and an annual license for $100,000. That's all covered in lines 454 through 470. Page 19, line 473, 5027-131 is some other language that I want to point out that I will be looking at as we move forward. As we've heard earlier today, I mean, this is clearly a work in progress as well. It does allow for, this would be, let's say, after the effective date and we've issued licenses and people are operating, if there's an opportunity for somebody to come into the state and get a license, but they already operate in a different license, it would allow the lottery, should they see so fit, to allow them to temporarily operate as they're going through the licensure process. I'm going to look at that a little bit further, but I just wanted to point that line out to you. That's section 5027-131. Moving on, page 21, line 513, you'll start with 5027-132. This defines what entities are not eligible for a license. We wanted to make that clear. Certainly, employees of the lottery. Individuals like that, employees of professional sports teams or any of the governing bodies, coaches of collegiate or professional other teams. You'll see all that in that section as well. Section 5027-133, page 22, line 548. This is where we get into the ability of Type 1 licensor or eligible entities and who those entities are. So when we were looking across the 36 states that have approved online betting or sports betting, we looked at there's a various range of how many licensees there are. You have New Jersey, who's been the longest running. They have actually up to 23, whereas Tennessee, our closest neighbor, I believe is operating right now with 9. So there's a range of how many licensures there are. We quite frankly, picked a number. It's right now it sits at 16, and the breakdown of that is we wanted to cover our hometown or our home state major sports. So the Hawks, the Braves, the United, the Falcons, and the Dream. 3 licenses to cover the Masters, PGA, and NASCAR. The additional one additional master license for the lottery, should they choose to run their own sports book, and that leaves 7 licensures for the at-large. Based on what we've seen, based on what I've seen in other states, it would seem that allows for enough competitive market to put people in place, but not opening it up to kind of some more fly-by-night, me and Houston Gaines scrape some nickels together and decide to start our own sports book. Moving on to, that also, excuse me, before I move off from that, it also goes into, I'm sorry, I misread that. We're going to get into, I'll just say this. There's going to be a launch date. So what the process will be is these applicants will all apply. They'll have a date they can apply from. There will be a selection, and then there will be an effective launch date. So they all start at the same time. Obviously, it's just merely to not give anyone a head start over any other company. All right, moving on to part 3, which is page 25, line 609. This gets into how much money are we going to generate. Right now in the bill, it is at 15% on their AGI, which I previously defined how we were going to look at that. I do foresee that percentage going up, but right now it is at 15%. One of the things we have to look at, it's something I got into the weeds with a little bit yesterday, was, they're in this, obviously, they're here to make money. It's a business. So the higher we take that tax bracket or that taxable amount, we run the risk of pushing people to other states. We have the ability for them to the operators will adjust so that they're obviously going to be profitable. That inevitably potentially has the opportunity to hurt Georgians who are playing this lottery game of sports betting. We estimate right now, out of the first year, that we would probably see I've seen everything from 50 to 75 million, or a range of 65 to 90 million. I contend that this is happening so prolifically behind the cover of darkness, if you will. It's hard to put a number on that. We don't know how much exactly the Georgians are betting, but we know they're doing it in abundance. Going back to my original intent is I want to protect those that are doing it. Just last week, there were 11 people across this country, one of which was from my hometown of Athens, Georgia, federally indicted on running a massive money laundering, sports betting book. So it is happening, and I feel like very strongly that we have set up for there to be proper guardrails to protect those that are engaging in this activity, which is a perfect segue to part 4, which are the guardrails and how we are going to protect minors from being involved in any of this. It goes, so section 5027-160, page 26, 649, line 649. This goes into the restrictions and the licensees on who they can offer their services to or an account to be able to place a wager into it. It obviously covers, most of it is covering the minors and getting into the fees. I'll get into the fines in the next section, which is on page 27, 671. Again, specifically on line 721, it shows the monetary fines. That is also something that I would like to continue to look at. I do believe that they have I would imagine every operator, reputable operator, has every vested interest in the world of not engaging in that behavior. I don't think that they're in the business to entice minors, but I do want to make sure that we properly warn them to make sure they're doing everything that they need to do to ensure that that's not happening. Moving on, section 5027-163, page 29, lines starting on line 727. This is prohibiting what you can actually place wagers on. They don't want to. You don't want to place a wager on Representative Scoggins is going to break his leg today. Certain injuries, stuff like that. It gets into what they're prohibiting. Part 5. This goes into all the language. This is line 755. It begins on page 30. This is how these operators are going to verify how to protect minors and how to verify who is creating these accounts. It goes extensively into this is where you'll see at one point there was a draft of the bill that actually included the use of credit cards. I had that struck. Clearly, I do not want to be part of in enticing someone to get behind in credit card debt because they're chasing a bet. So there will not be allowed to use credit cards. Obviously, a debit card, but that is at least a cash system, so that you are not getting behind in credit card debt. That is all covered in section 5027-170. 5027-171, which is page 33, starting on line 823. This is the problem gambling language. So this is where people will be flagged if they have an issue. For instance, I fully intend on adding a line to this that should somebody place a bet that Georgia Tech should win anything, they should automatically be put on a list. Oh, I'm sorry. No? Too soon? Too soon? Okay. All right, fine. We'll leave Georgia Tech alone. No, but this is where you want to make sure that if the operators, they see the warning signs, they can see the patterns of behavior, and this is what covers what they need to continue to do to implement those types of problem gamblings, and what it requires them to advertise a message to prevent problem gambling. Part 6, page 35, line 860. This is what this is covering is when it starts talking about data, what this would say is that it doesn't for certain wagers where an event is happening, like we'll use FIFA for example, it's happening overseas, it's happening in a place that a league is not headquartered. It's just simply saying that we understand that the league is not the one validating that the score of that game. It's happening elsewhere. That's merely what Part 6 covers. Part 7, page 37, starting with line 932. This gets into what the authority being given to the lottery. And I'll roll through because it's a bunch of sections back to back to back. These are things like this allows the lottery to enter a premises, to inspect the books. This is all the things that we need to ensure that we have the authority to properly go in, audit if we see a problem. This just simply outlines the civil penalties, the subpoenas that they're able to do, ability for a licensee to appeal the decision to the Superior Court of Fulton County. It makes it a misdemeanor for any person directly, indirectly, knowing to receive, supply, broadcast, display, otherwise transmit material, non-public information. So this gets into how we can go after them and all of the authority that the lottery has. Part 3. This gets into right now, currently in criminal law, it is criminal to bet on sports. So these last couple of sections, section 3.1, 3.2, and 3.3, cleans up the criminal law that would be in conflict with us allowing for the lottery game of sports betting. Y'all, I ran through that obviously very quickly, but again, I will say that we need to put guardrails on what's happening. This puts money directly into the lottery program. It's funding pre-K, funding Hope. We backfilled Hope for $60 million last year, year before. There are reasons to do this to make sure that we're funding the education properly, but also protecting Georgians who are clearly engaging in this activity properly, and protect them as well. And I will stand for questions.
Thank you, Chairman Wiedauer. Okay, let me sort of set the stage. I thought we did a great job in the last segment of keeping our questions on the bill. We'll obviously have a lot of robust comment and debate at the appropriate time. Let me also say this. It's a large bill. I'm going to ask Chairman Wiedauer, and I know our attorneys, as well as there may be people involved in that know the bill. I'm going to ask them to put together for the committee, and I'm not taking anything away. Then you're putting your own eyes on the words on the paper, but I'm going to ask them to, on a section by section basis, label it for us, and what I will call public facing and back office. The public facing is how we interface to make sure that you're geofenced and you're only playing this lottery game in the state of Georgia. That's a public facing and interfacing with our people. A public facing thing would be to make sure that people under a certain age can't participate. That's public facing language. The back office facing, still to be vetted by this committee, but the back office facing language would be those things like the gentleman just mentioned about how scores are validated. That's sort of perfunctory language that is important for us to vet, but I think it probably is something that we are less honed in on than how it interfaces with our things. So I want to do that and ask the chairman, along with some folks I know help, as well as our attorneys, to guide us in that, to provide us, because I know a lot of people, I know we have a lot on our plate, and I think that would be helpful. I know for me it would be, as a non-lawyer, to know what we can really pay the most attention to. So I hope that'll help, and I hope you can help us as we move the bill forward. You had a couple of questions. I hesitate to go here first, Chairman Wiedauer, but we're going to Chairman Dubnik down there. You've opened up a can of worms with the tech comment. But go ahead, Chairman Dubnik.
Thank you, Mr. Chairman. Two quick questions, and I'll get with you on the rest offline. One, college sports. How
It is included.
it is included, so it is allowed.
It is allowed in this bill.
Okay. If you could go to line 557 with me. Page 23. Corporation shall issue not more than 16 Type 1 licenses. Why are we limiting it?
I spoke to that briefly. So if it's the pleasure of the committee, we can talk about opening that up further. I was looking at across the states how many licensees are actually engaging in this, and I do believe that, look, and all joking aside, obviously the Braves have done well, that Georgia has done well. I think Georgia is, it is obviously very ripe for sports betting. I do think that you're going to see operations pop up that may just want to operate in Georgia. I wanted to do my best to protect the integrity of the operators that are coming to Georgia for the benefit of Georgians. I do think we have good guardrails on that for their criteria.
I'm just going to get us back on point just for that. So the number the gentleman picked because he thinks that's a good starting number. He's not married to it. That we'll have that in the breast of the committee. I would remind, and I think I missed, there's $100,000 application fee at $1 million a year. So it's the chairman and Representative Gaines must be doing pretty well over in Athens if they're thinking about opening one. I'm joking, of course, but it's a number. We have that before the committee. Anything further, Chairman? Okay. Yes. And you're going to work on that Tech Georgia thing offline, you said. Okay. Chairman Knight.
Thank you, Mr. Chairman. Chairman, I apologize. We had to go to Ways and Means, so if I missed part of the presentation in regards to this question, forgive me. But on line 258, page 11, 258, there's a definition, and again, I'm sorry, I don't bet, so I don't understand what the
I
it
needed
is,
that
but-
explained to me too as well. So what that is, that was early on in the presentation. So certainly understand. I think I missed ways and means as well. So a type 1 bet is a simple, like an over/under, a bet against the spread. Okay. A type 2 bet is what you call prop bets or end game. So, and I'll use a PGA. I mean, the reference I used earlier was, is Tiger Woods going to miss this putt? That is a type that, like, literally you can.
Or is somebody going to strike out?
Yes.
All right.
Number of yards in that
Yeah.
someone would gain
All right.
in the Super.
So you can bet on anything.
This is the coin. You can literally bet on the coin
right.
toss of the Super Bowl.
All right. And Mr. Chairman, if I can, the second question or comment, maybe to get a little clarification or at least start a discussion to make sure I'm understanding this. Page 38. And this is, I think, in regards to the license, the inspection, and I'm seeing some language in here. It says use commercially reasonable efforts to cooperate. Let me give you perspective or background. I've seen throughout the state in which private contracts basically, I guess, protect the public. And when we as lawmakers want transparency, to see exactly what is happening, we run up against issues in which the private organizations will say, "Whoop, I'm sorry, that's proprietary information." Many of you know what that probably is stemming from. I want to make sure that that this is very clear that there's total transparency, and that the state can go anywhere, do anything, and not be hindered by some wall of, "I'm sorry, this is proprietary information."
Agreed. And I'm happy to look at that language and make sure that's protected. I do believe that all of Part 7 in its entirety will allow for that. In that particular section, I see the language you're talking about. We certainly will look at that. But I do agree with you, and I do believe that that's covered sufficiently in Part 7, but we can definitely look at that and make sure and ensure that.
We'll make note of that. Anything further, Chairman Knight? All right, I'm going to go Dr. Clark, number 2.
Thank you, Mr. Chair. I have kind of a broad question just for understanding, because I looked this up and it seems like every state doesn't actually allow the sports teams themselves to be licensees. Can you, like, for example, if the Hawks are licensee, how do they use that license specifically? Like, what will they do with that? Are they letting people bet on the Hawks game during the game?
So I know that I'm certain that the teams would love to speak to this at some point, but again, the Hawks would not, in your example, the Hawks would actually not run their own sports book. So the Hawks are going to, again, partner with somebody, and it would be the such and such is, the official sports book of the Hawks. Now that sports book they're going to operate sports betting. There's not going to just be Hawks betting. But there's some integrity there with the league data that they're trying to protect there. So I'll let somebody else speak to very specific details on that, but that is the intent, is that the Hawks wouldn't actually run their own sports book, but merely partner with an operator.
Again, Dr. Clark, that's something we can talk about as a committee. I think your question, and I want to ferret it out fully, is it's your information that this is not done in a lot of states, and the question is
I'm
why.
not saying a lot. I'm saying all states don't
Okay,
allow
fair
it.
enough.
So, and I have one follow-up.
Yes, ma'am.
Line 625 through 628 talks about how the privilege tax basically takes the place of all other state and local taxes. Can you speak about that? So the taxes will only go to the lottery, but wherever this is taking place, those state taxes and local taxes are just not being paid at all.
You're talking subsection E there?
Yeah, E.
If I can, just in the interest of time, the lady brings up a good point. So we'll get with the attorney. We'll also get with Mr. Travis in Ways and Means, Chairman Wiedauer to. I mean, when it says all state and local taxes, that would to me infer that if they had an employee in the state that they wouldn't pay state taxes. So we need to ferret that out and get an answer for the committee. We'll do that at the,
Yeah, and as I read it, I think that's just merely saying that they're still gonna pay all the other taxes. This is in lieu of that. But I'll make sure that I answer that question thoroughly.
We'll look into it. Yeah, but good
Thank
question. Chairman Perkle. What number are you down there? Are you 28, Chairman Perkle?
Yes, sir.
Yes, sir.
So while we're on that 700s, if you would look on 719, and this follows what I will just say the naughty list. Those bad actors that should not be, if you're a student, some information. If you're an employee and information. So bad actors, the naughty list. And it shows the punishment, as you would. First offense, line 720, misdemeanor. Second, 500 to 1,000. Third, guilty of misdemeanor of high negative and 750, imprisonment, this and that. So where there's money involved, I've noticed, I've had a tendency to see that people will gravitate to try and game the system. If there's money involved, it appears human nature. Some of these on the naughty list that should not be placing bets, perhaps we'll try to do that, and perhaps they're doing that now. Is the punishment appropriate for, if I could make $50,000 on this bet by running over the star running back's foot with a wheelchair? There doesn't appear to be, and maybe that's in the rules and regs and what the authorities will do. You don't get the $50,000 plus I'm going to fine you. It just appears to me, and there again, I don't know, that you're first guilty of a misdemeanor, or they don't have to pay $500. Well, even a Georgia Tech guy can realize I swap 500 for 50,000 every day.
I'm gonna handle this one for us just in the interest of time because we're just getting started. So the gentleman brings up a good point. We'll look at, and that was part of what the chair mentioned earlier about we're going to focus on the public facing portions of the bill, and that's a fair question. And we'll get with again. You raise a good question. We'll get with the folks in judiciary. My suspicion is there are other criminal penalties that would apply in addition to this, but you raise a good point.
Mr. Chair, if I may, though, I in the presentation, that is the line that I actually singled out as saying that I was actually going to look at the monetary fees. So you and I are closely aligned there.
I looked it up while you're on here, and in 1933, they arrested a man for robbing a bank. They asked him why he did it, and he said that's because that's where the money is. So the gentleman is correct as that does it. The former secretary of the committee, Representative Bentley.
Yes, sir. Thank you, Mr. Chairman. And Chairman Whittout, I'm sorry I had to leave to go to Ways and Means. But I noticed it was mentioned about the license, the type of license, and the fees for the license. I'm just concerned that we don't run into a similar situation like the medical cannabis with these licenses and someone, now there's some litigation and everything is kind of moving slowly in that regard. Is this bill tight enough that we probably won't face those type of challenges that will prohibit us from doing what we are trying to accomplish with this bill?
I will say that I believe it to be so. I also, Chairman Dubnik mentioned asking about where he came up with a number. That's something we can discuss. I'm not married to a number, but it is a starting point on what we've seen as operators in other states, the quantity of licensees. But I'm happy to have that discussion.
Yeah, I was just asking just to make sure that once this bill does become law, that we can move forward on it and won't have to be tied up in court litigation because of a license issue.
Yes, ma'am.
Yeah.
Representative Bernal.
Thank you, Mr. Chairman. I just had one question. I think it's in line 727. and it's talking about, I know you said that those are things that you cannot do, bet on injuries, but how are the athletes, especially since if our college athletes, they can bet on their games, how, are we doing anything to protect them?
They can't protect, I'm sorry, I thought I heard two different questions. So they cannot bet on, it is prohibited for anyone that has anything to do with that to be able to bet.
Mhm.
But I think that was one of the things you might have said. As far as protecting them, you know,
Let me ask, was the lady talking about protecting them from betting on that?
Protecting them because they are the athletes, because people will approach them. It's just like, now they can, they're their own advertisement and they get paid for that. So is there anything that's going to be there to protect them in case someone does come and try to entice them to bet or to ask them for information?
I think those, unfortunately, those things exist right now, and that's part of the problem. Is that it doesn't keep, you can't keep somebody from going up to anybody. I mean, that's true here, it's true now.
Okay, thank you.
Minority Whip, Representative Park.
Thank you, Mr. Chairman. So 2 questions, if I may. First, could you speak to the constitutionality of the bill, especially after the previous presentation in which the former Chairman Powell seemed to be very clear that anything that would provide cash as gambling would require a constitutional amendment. And then 2, when it comes to the fee that would be imposed, the 15% of adjusted gross income on line 611, is there analysis that could help this committee and this body maximize the amount without necessarily driving folks out, but ensuring that the state is receiving as much revenue as possible for purposes of education? But certainly the constitutional piece would be helpful.
And that's where I'm going to do my public service announcement on this and say that first, and then I'll go to you. But certainly the fee, I think they call it the privilege tax, that is in the breast of this committee. That's what we do when we vet the bill. So we'll give that a look, and I'm sure that the chairman can comment on that. As far as the constitutionality, I meant to mention this and actually spoke to one of the minority members, a learned attorney on that. As people talk to this and testify on this, you're welcome to spend your time arguing constitutionality if you'd like. With the exception of a few of us up here, we're not attorneys. It is my opinion as chair, and what I will do when I use my judgment is this good policy for the state. It is if someone wishes to challenge the Constitution, but I want to go again and say this is another lottery game with the funds going, to the same place the rest of the lottery games go. So with that, I hope people will look at this from a policy perspective. And should it pass and should it become law, then that process will go through every other law that we have here. I don't think there's a black letter solution to this. I think we could probably line up a room full of people. Half would tell us it is okay constitutionally. The other half would tell us it's not. Now, I think you're a semester or two shy of a law degree either. If you wish to opine on that, I'll stop now and let you do so.
I will say this. I mean, just echoing. I mean, I think, like the chairman said, I think you're going to line up you could line up a number of people that will have conflicting concept. I obviously would not be bringing this if I did not believe that it could be done in this manner.
Thank you, Mr. Chair. Just a quick question, line 784. How are we ensuring that people do not sign up for other gambling programs like FanDuel and stuff like that? So is it pretty much they can't sign up for FanDuel and online sports betting?
Somebody would be able to, if they wanted to, using your FanDuel, and let's say the lottery has their own sports book, they would be able to sign up and have an account with FanDuel and with the Georgia Lottery. What this is saying is they can't have multiple accounts with the same licensee.
Okay.
Some of that is, again, if they're incentivizing in certain ways, we're just trying to protect that it is one individual, one account per licensee.
May I follow up? Yes. How do you assure that they're not just making another account under another name and doing
So,
it like that.
so all of these, if you go back up in that, the like lines basically 766 through 779, they literally can get to the point of requiring a notarized document. It's a pretty stringent protection to make sure that they're dealing with the individual that is actually trying to sign up for that account. Thank you. Yes, ma'am.
To the gentleman, my minority member of the minority party that helped me earlier, Representative Hawcom.
Thank you, Mr. Chairman. Is it true that this will only apply to bets that are made within the physical jurisdiction of our state?
That is correct.
Okay. And then the second question is with respect to the material non-public information side of it. One issue is, interestingly, in the securities law context, this isn't codified of insider trading, which is effectively what this is. But there is an issue of what's called tipper and tippee, to where you have information and you don't make the trade or the bet, but then you hand it off to a friend. And so one thing that I would offer to be considered is to have that loop closed too. So it's not just the individual that has it, but you can't just hand over the information to like your roommate and then have that person execute.
Understood.
Thanks.
Oh, thank you, Mr. Chairman. I share your concerns about enticements. This idea of here's $100 free for your first bet, or you haven't been here in a while, $200 on us. I've heard concerns in other states that when the licensee offers that sort of incentive, they then can claim that as a loss against the taxes that they should be paying to the state where the state's supposed to be generating the revenue. I would support this idea that maybe we look into language in prohibiting enticements at all, both because I think it's a little bit of the devil's game to get people engaged in the gambling, and because I think we would need to look at how that could impact what the state's revenues would be if we were allowing the licensees to then call those losses as part of their operations, if that makes sense. That wasn't so much a question as a concurring that we might have concerns about the same thing.
Thank you.
Are there further questions? Further questions by the committee at this time? If not, we have, I would like to, we have a couple of, we have about 10 minutes before we have the hard stop at noon. We have a sign-up sheet. I'm sorry, did you have anything further you wanted to?
No, Mr. Chairman, I just
We're going to come back to you after comments, by the way. So this is not you're not your final bite at the apple today. I just didn't know if you wanted to wind up before we went. All right, so I'm going to ask the same thing. We have a number of people that are signed up. I mean, the way it is, we can give. It looks like we can give everybody about a minute if everybody wants to talk today. So we can do that, or I can ask if anybody has a compelling reason they can't join us back on Tuesday. We'll go in that order. I'm just trying to be flexible. Sometimes I do that to my detriment. But is there anybody that is signed up to speak today that is here that can't join us Tuesday? If you are, please come and identify yourself. If you could also be brief, there are people signed up. We're going to try to do that. But if you would identify yourself, and you can submit the rest of your notes for the record. We'll take that as well. Yes, sir.
Okay, thank you, Mr. Chairman and members of the committee. My name is David Miller, and I'm with the PGA Tour, the professional golf organization. This state holds an important and famous role in professional golf, and this is an important issue. Sports betting is an important issue to us at the PGA Tour. We support HB 380 and the regulation of sports betting in this state. We think this bill is as strong as any in the country that we've seen across the 36 states that have legalized, and it's supported by essentially all the leading betting operators and sports leagues in the country. Tiger Woods was mentioned a couple times today. The reality is I could pull up my phone right now, or you could place a bet on whether Tiger makes a putt today with an illegal operator. That does nothing for the state of Georgia. That money just goes to offshore operators when it should be going to the state for education and for in-state businesses. We think it's much better to go ahead and regulate this activity. It has integrity benefits. Chairman Knight, there is transparency for the lottery, through this model into the operations of the bookmakers. There are protections for athletes. That's something we take very seriously. I think this bill also has good consumer protections, keeps people out of the illegal market where they don't care if you're addicted or underage, generates revenue for the state, obviously, for teams. Dr. Clark, or Representative Clark, you're correct that not every state has licensed the teams or sporting events, but that there are 5 that have done so now, and that's certainly the trend. I think the idea is to benefit the in-state businesses, not just have it be really an out-of-state bill, and help the teams improve help the teams improve their product in the field, and help boost sporting events in the state. So for all those reasons, we support this bill. Thank you, Chairman Wiedauer. Thank you all, members of the committee. Appreciate the time.
That's your pleasure if you'd like to leave us any notes. We have that. I think if we'll take a minute each if you'd like to speak, or if you'd like to wave and come back on Tuesday, we'll give you more time. But I'll just go down the list. And again, if you speak today for a minute, that does not cut you. We're not going to say you had your bite at the apple and you can't come back and talk to us at a different time. We're just limited today. Professor Kine, you're the first to sign up.
I'll wait. As you can see, I'm 6'7", and I know higher education.
Yes, sir. Yes, sir. Mike Griffin, do you want to speak with us briefly today? And
Yes,
you're
sir,
welcome
will.
back another time as well.
Thank you, Mr. Chairman. Appreciate it. I am Mike Griffin, Public Affairs Representative with the Georgia Baptist Mission Board. We have handed out to you a resolution that we passed in 22. The Georgia Baptist did against sports gambling. We do represent Southern Baptists in our state, about 1.5 million. So our concern is, the moral issues, and you see that on the resolution that we have there. The socioeconomic issues, we're concerned that we do have a fire burning here in the state, but we're fixing to put gasoline on it. And it's the detriments are going to far outweigh the benefits in the long run. Legal issues, we are concerned about the constitutionality of this, that it is not going to meet the legal ramifications that are needed, and it appears that the sports gambling issue industry is doing, we're talking about sports, an end around, because they see that according to AJC, the popular polling has gone down 8 to 10 points, somewhere around that, from people being in favor of this. And I think there's generally an integrity issue here. The people in 1992 were not voting on this. And I think going forward, if we're going to be faithful to our Constitution, this would have to be a constitutional amendment. And the people in the state of Georgia would have to make the final decision, not the legislature. I'm not for that by way of pushing that onto them. But if there was going to be this, the people in the state of Georgia would need to make that final say. Thank you, Mr. Chairman.
Mike, we'll be happy to have you back when we can give you more time.
Thank you. Thank
Mark
you, sir.
Parnell. Mr. Parnell, am I saying that right? Mac, not Mark. I can't tell if we have an H or an R there. Mac. Do you wish to wait till later? Well, now we are. Nick Fernandez, Metro Chamber. Do you wish to?
I'll speak on Tuesday.
Thank you very much. Brian Hudson.
Mr. Chairman, I'll wait till next week.
Jeremy Cooten.
Mr. Chairman, I'll wait until another time.
Okay, there you go. Well, bless you all. I want to thank everybody. I want to thank Chairman Wiedauer for the question. I'm going to give him a minute, and then I'm going to set the stage for where we're going forward. So, Chairman Wiedauer.
I'll just conclude with, my door's open. I want this out there. I want it thoroughly vetted by everyone involved. This is bipartisan, and welcome any commentary, and I appreciate the time today and the questions.
Thank you very much. Okay, here's what we're going to try to do. We're going to have further comments on the process. We're going to make every effort we can as the bill is perfected moving forward to keep that language in front of the public and keep it front facing. I'm going to work with the Speaker's office today to find a way that we can point you to the latest updates. We'll make a better public notice of what that will be before Tuesday or on Tuesday. In the meantime, call the office, call our office if you work on a copy of the bill. And the license. So we will meet Tuesday. I think the time is going to be in the afternoon. I think it's 3 o'clock. I'm going to ask, we're not going to break this up into subcommittees for work. I want every member to look at every portion. But when you ask a question, you kind of get invited to the party more so. So Representative Hawkins, you brought up the tip-or. Am I saying that right? I'm going to ask you to work with Chairman Wiedauer on helping us to find that language where it may be there. Representative Holland on the issues around what I call spiffs or promotions. Chairman Perkle, you had some thoughts on another thing, so I'm going to invest you to get some of our colleagues to do it. And with that, everyone is invited to provide feedback to Chairman Wiedauer, and we'll try to filter that in and improve the bill. But we will look at working on this item, LC 365493, and our office in higher ed will do our best to make this available electronically, so you can pop a Google site or whatever and pull down the PDF of that. With that, thank everyone for their attendance. This is the beginning of a process. We'll continue it, and it'll be open and public. If there's no further business for the committee, we'll stand adjourned without objection. Seeing none, we are adjourned.